You guys know normally we do COVID here on the show, but we're not going to do that today because I promised you guys the March 22nd full pretrial hearing that was 11 minutes long. So let's go get it done right now and watch together.
Domino Masters is this.
Right, now let's take a look.
Your Honor, calling People v. James Crumbley, case number 22279-989FH. Your Honor, calling People v. Jennifer Crumbley, case number 22279-990FH.
Good morning, Your Honor. Turn this down here on behalf of the people.
Thank you, Marquise, on behalf of the people.
Good morning, Your Honor. Marielle Lynn on behalf of James and Jennifer Crumbley. As you know, my co-counsel is ill and not able to appear today.
Yes, I heard that. Please tell her I wish her a speedy recovery.
I will, Your Honor. Thank you.
All right, good morning. You can be seated. The court is aware that the prosecution has filed a motion entitled Joint Representation Safeguards, and that motion is set for tomorrow. However, even prior to receiving that motion, the court intended to address this important issue sua sponte. The court is cognizant of the defendant's Sixth Amendment rights to retain counsel of their choice. But the court is also obligated and committed to preserving a defendant's right to a zealous defense. Michigan Rule of Professional Conduct 1.72b indicates that a lawyer shall not represent a client if the representation of that client may be materially limited by the lawyer's responsibilities to another client or to a third person. Michigan Court Rule 6.005 states that whenever two or more defendants who have been jointly charged or whose cases have been joined are represented by the same retained lawyers or lawyers associated in the practice of law, the court must inquire into the potential for a conflict of interest that might jeopardize the right of each defendant to the undivided loyalty of the lawyer. The court may not permit the joint representation unless 1. The lawyer or lawyers state on the record the reasons for believing that joint representation, in all probability, will not cause a conflict of interest. 2. The defendants state on the record, after the court's inquiry and the lawyer's statement, that they desire to proceed with the same lawyer. And the court finds on the record that joint representation, in all probability, will not cause a conflict of interest, and states its reasons for the finding. Joint representation of co-defendants charged in criminal matters by attorneys from the same law firm is uncommon. There is great concern that there may be a conflict of interest, as incompatibility of positions may arise at any moment. Of additional concern, Michigan Rule of Professional Conduct 3.7 states that a lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness. I don't yet know if that rule is implicated, but I want to be clear that a lawyer providing representation in this matter will not be permitted to also testify. These concerns need to be addressed both in the short term and in the long term in the event that these matters go to jury trial. To this end, the court is appointing independent counsel for each defendant. The appointment of counsel will not be as a substitute for the defendant's current counsel of choice or to report back to this court. The purpose of independent counsel will be for the limited purpose of advising each defendant in the matter with regard to joint representation and the potential for conflicts of interest. The court is aware that a defendant is permitted to make a knowing, intelligent, and voluntary waiver of his or her right to conflict-free counsel. I will be inquiring of each defendant at our next pretrial if they intend to waive any potential potential conflict. I will also be asking for a written waiver by each defendant. If it appears that a written waiver by the defendants becomes necessary subsequent to their meeting with independent counsel, I'm requesting the prosecution and defendants agree to language and present a proposed written waiver. In the meantime, I'm going to take the prosecutor's motion for joint representation safeguards, which is set for tomorrow, under advisement. I don't believe the defendants have responded to that motion. I'm also going to set another pretrial date, so I want to ask if you are all available April 5th at 10 a.m. I also want you to keep in mind that it isn't as easy in the past to set a court date. You probably noticed that we're not in the courtroom. There's a murder trial going on in my courtroom and the two adjoining courtrooms, so I can't just set things without asking. So,
Judge, the date works for the people.
Your Honor, I do see that Ms. Smith has a trial that day in another county. I can speak with her if you'd like to schedule it. I can speak with her regarding that trial.
All right. We're going to continue this when we come back. So, what we heard so far is that the next trial day is going to be happening. Next pre-trial day is going to happen April 5th. That's going to be like 2 or 3 weeks away. But we're going to hear more from their attorneys and ask the question: should they have the same attorney from the law firm? Stay with us. As you guys know, for months on this show, we've been focusing on the Ethan Crumbley case, where he got a gun, his parents bought him the gun, and he shot the school, and now the parents are charged with involuntary manslaughter. We've heard in past dates, Ethan's now in jail, the parents are now in jail separately. They're trying to get Ethan to go to juvie, and prosecutor Karen McDonald has asked the public, including myself, she didn't ask me, but if she ever watched the show, I'm gonna try my best to comply with the prosecutor's order if she ever watched this show. So let's continue on with the hearing.
okay, there are difficulties that we didn't have in the past moving things around. Obviously, this case is of great interest to a great number of people, so there's a lot of people to notify for a pretrial or any kind of proceeding. The other thing is that I'm sort of homeless right now. I have to, kind of look for a jury room, a courtroom, so that's jury free. So if for some reason you can't make that, you need to know in a timely way because it's more trouble than it used to be. So
I should be able to notify everyone today, Your Honor.
okay, and if you could get back to my staff, because we could arrange another date. I think I'm going to be in jury trial next Tuesday, so and I don't have a courtroom, so.
Judge, just one question regarding the written waiver form. People did attach as an exhibit a proposed waiver form. In counsel's response, I didn't see a specific objection. Counsel, do you have an objection to the language in the form attached?
I would prefer that we discuss this off the record and maybe confer and decide whether or not we approve of the language that's included in the waiver.
I don't think I've seen that because I don't know if I have that attachment. It probably was filed. But I guess I'd like it if you confer on that. I hope the Crumleys understand the purpose for the independent counsel. I'm concerned that at some point today, tomorrow, next week, a month from now, 4 months from now, that something could happen to cause a conflict that could damage your position, Mr. Crumley, or your position, Mrs. Crumley. And
These ads just make me want to pee.
about your rights, and I'm concerned, as we sit here right now, that there could be a myriad of things that are incompatible. So I'm sending appointed counsel, independent counsel, and their job isn't to report back to me. Their job isn't to take the place of your attorney. They're going to talk to you about a conflict of interest, potential conflict of interest, and what would be in your best interest. So I would urge you to listen to them and ask them any questions you might have. Because obviously this is very stressful for everyone involved. I'm trying to avoid your rights being implicated in a negative way, but I'm also trying to avoid having to recreate or go backwards with regard to this case. For example, if the matter is in trial and there's a conflict in the middle of a trial, that could cause a mistrial. I'm sure it's no surprise to you that the court is very backed up. I happen to have a fairly reasonable docket, but some of the judges in the courthouse are trying cases where individuals have been in jail 700 days. And that would not be my intent if your matter goes to trial. I would give you the speediest trial possible. However, if there's a mistrial because of some conflict that arises during a trial, we'd be back at square one. So I want to avoid all of that. All right? So you should be visited within the next 2 weeks, and they'll talk to you about these issues. Your lawyers might also have positions with regard to this. Now there's the preliminary examination, transcript is available, and discovery, and that could make a difference in what you choose going forward. All right? Anything else?
Judge, just procedurally, so I understand, the court will appoint independent counsel. Counsel will meet with the Crumleys separately.
Separately, 2 separate lawyers.
Okay, 2 separate lawyers, and that is in the presence only of the independent attorney with the defendant. Am I correct?
Absolutely.
Okay.
Absolutely. The independent lawyer will be there with Mrs. Crumley, and a separate independent lawyer will be with Mr. Crumley. Absolutely.
Thank you, Judge. And I'll work with opposing counsel. We'll put together a form and send it to the court.
I appreciate that. If at the next court date, I'll be wanting to move forward, and I'll be asking both sides what kind of motions they might have to file. Okay? Anything else?
For the people.
Nothing from the defense, Your Honor.
All right.
So
So
I assume because you disposed of the other motion that tomorrow's date is off.
correct. That's correct. I hope Ms. Smith feels better.
Thank you, Your Honor. I appreciate that.
All right. Thank you. All right.
So in a couple weeks, the new pretrial date is going to be set for April 5th. That's in 2 weeks from Tuesday, and we're going to bring the very latest on that day. I'll give you right Tuesday, where we look at 2 weeks from Tuesday. So in 2 weeks from Tuesday, after that, we will play you the new pretrial hearing. But there's something else you haven't covered. When we come back, there was a man who gave the parents a 9mm and gave it to Ethan as an early birthday present. Well, guess what? That person is testified about a month ago, and we'll hear that. We'll hear that when we come back. Stay with us. If you're just joining us, we looked at the pretrial hearing, the first one, the full one, 11-minute one from the Crumleys. Now, this next one's gonna be set from 2 weeks from Tuesday, and on 2 weeks from Tuesday, a special Give Me a Break. I'll look into that, so look for that. So you might want to check your local listings. But there's something else we haven't covered. That gun store manager that sold the parents that gun, he testified in court about a month ago. So let's read it from MLive.com. After Rogowski testified, the prosecution called Cami Black, the office manager for a business that sells guns, to the stand. Black said he sold a 9mm 6-star SB trigger lock to James Crumley on November 26, which was 4 to 5 days before the shooting. Back recognized Crumley as he has made several purchases from the business before. He was accompanied by the store by a juvenile male, presumably his son. But cross-examined by Lehman, Backett said Crumley didn't make any statements that he indicated to buy the gun for his son. Had he suspected the gun was from Ethan, she would have sold it to his father, she said. But now we also heard from the council. So if you've been watching this case, we've been looking at everything. From accountability to the counselors, the teachers. Pretty much everyone. Pretty much everyone in this case. The gun manager. The counselor. Tim Throne. He quit his job and now this person got replaced because, I don't know, he held out his retirement after whatever. But what I have to say about that is it shouldn't happen. For one, because you could be blamed if there was a real trial, you could be in real trouble. You should have quit your job. You need to stay where you're at. But probably doesn't matter, so wait a second. It does matter. That person was superintendent. He quit his job he retired for a reason, probably because of all the evidence and damn evidence. But the school's still investigating, and parents are concerned about this because they're looking to a third party. And now with the new superintendent here, we don't know what's going to happen. But what we do know is that they're going to avoid lawsuits. This continues to happen, so we probably won't know. What we also know is that Ethan wanted to be a video game designer to go to high school. Well, he has a criminal record, so he cannot be a video game designer, or he can't go to college because of what happened. So this was all from those text messages. So on April 5th, we'll give you that special, and we'll give you that very latest. Now, as I said in this 5th season, we're going to be dealing with education topics. And since I created this brand new channel a week ago, we're going to revisit some topics like dress code violations in our schools. That's the big issue here. Even if you were to look on news stories or look through what goes on, like we'll give you that topic when we return. So as you guys know, I created a new channel a week ago dedicated to my old channel I created 5 years ago, where I post old videos where it's just gonna be give me a break, the official one, but there's gonna be some new ones and probably some revisiting some classic breaks. The reason I call it classic break, we're revisiting some old topics like we talked about, dress codes. This is the 5th season, so let's take a look at some dress code violations. Take a look at this one.
Short, too strict. There's a dress code backlash going on at Elkhorn area middle schools.
This after parents and students say Staff are being too strict about what can be worn to class. Pete Servakis live in Elkhorn with what happened today.
Well, Charles and Shannon, a student and her mom say about 20 girls were removed from class here today for violating the dress code. This video, captured by an Elkhorn area middle school student,
dress coded,
shows girls deemed to be in violation of the dress code. According to Ursula Monsler-Bell, a teacher pulled her and several of her friends out of class because their shorts were too short.
It was surprising and really irritating how many there were of us.
This photo shows the girls waiting in a school office. Monsler-Bell's mom eventually took her home for the day.
I'm her parent. I feel like I'm the one that should be making the choice of what she wears up to school.
The school dress code says clothing should not be a disruption. It reads, skirts and shorts must be of an appropriate length and extend to the fingertips or longer when the arms are placed at the sides.
If you have short arms, you can wear short shorts.
Monsler-Bell and her mom admit her shorts were not compliant, but they want the policy changed.
I'm covered. I'm not distracting anyone. No one complained to me besides a teacher.
Now, the school dress code specifies it's the principal who has the final say on any disputes over dress code between a student and a teacher. We did reach out to the principal here at Elkhorn Area Middle School today, but did not get a response. Live in Elkhorn, Pete Servakis, today's TMJ4.
Like what I had said before, it doesn't matter. Now imagine getting suspended without looking at the disciplinary code.
More than 100 suspensions handed out there at Wilby High School in Waterbury. They were handed out last Friday for dress code violations, but we've heard that the school just acted too fast.
News 8's LaSalle Blanks explains. The big lesson at Wilby High School these days, pay attention to the dress code or you'll end up like these students and more than 100 others who were suspended last Friday.
They stopped me in the hallway, they rolled me up, told me to go to the office, and that's why I got suspended. But which wasn't fair.
Michael and his friend, who was also suspended, were surprised.
They weren't the only ones who were surprised. So were members of the Waterbury Board of Education, and they wrote the policy. Listen to their reaction when News 8 asked them about all these suspensions.
I was shocked. Bob Brenker is the Chief Operating Officer for the Waterbury Public School District. He agrees with Michael because he says Michael and other students should not have automatically been suspended, according to the Board of Education dress code policy guidelines written in July of 2005.
We didn't follow the 4 steps that are right in this policy.
Those state that if it's a student's first offense, that student should get a written warning, not a suspension. The second offense is a detention. A 1-day suspension doesn't come until the 4th time a student violates the dress code. Many students wish.
And honestly, this whole dress code, I feel like it should just go away.
Brenker disagrees with that. He says the board believes dress codes enhance the learning environment in schools. He just says the principal may have handed out many of the suspensions too soon, in violation of the board's own policy.
We didn't follow our own policy. As adults, we should follow our policy too. So now we've taught students that if they do something wrong, it's okay, they'll be disciplined for it. But what happens to the adults, the people that do the suspensions? We should know better.
In Waterbury, LaSalle Blanks, News 8.
And they have to follow their own steps. You can't just follow your own steps. But imagine being an honor roll student when you're a senior, you're almost ready to graduate, and you have a dress code that exposes the collarbone. So what that means is because it's a distraction. So let's take a look.
Sure, tonight it is at the center of a controversy. A straight-A high school student says this outfit got her suspended for 2 weeks, and now she won't be able to graduate despite having multiple scholarship offers. NBC Charlotte's Tanya Mindus joins us live tonight. Tanya, you spoke with her parents and the school, and of course we know there are multiple sides to every story.
Well, of course, and this school doesn't mess around when it comes to its dress code policies. In fact, earlier this year, 45 girls were brought into the principal's office just because they were wearing leggings without shirts that were long enough. So to say that this school takes it seriously would be an understatement. Well, this girl says that what happened with her dress code spun so far out of control that now she could be expelled and her scholarships that she needs could be gone.
I'll never wear a shirt.
Summer knew when she wore that shirt to Hickory Ridge High.
I had it right here, so the tops of my shoulders.
She could be violating the dress code.
It's usually taken really seriously.
The school makes it clear off-the-shoulder tops are not allowed, and the principal came to enforce it in the cafeteria.
She came up to me, she said, "Do you have a jacket?" I said, "No, I don't."
A friend gave Summer one of hers. She thought that was the end of it.
And then I, pulled it up, pulled the jacket over it, zipped up the jacket.
But Summer says the principal wasn't satisfied, ordered her to go to the office to change. The honor roll senior has had issues with the principal before, to the point where her mother had to get involved.
I said, "I apologize, but I can't go anywhere with you unless my mom is on the phone."
So Summer sat and waited for her mom's call. That's when Summer says the principal called the SRO for backup.
Officer Elwood was within 5 feet of me, had his hand on his gun. She said, "I'm going to give you an ultimatum. We have tried to call your mother. You either come with me to the control room to change your shirt, or we will arrest you."
Summer's mom would eventually call back, so she agreed to go to the office. But by then it was too late. The senior with a 4.4 GPA, suspended for 10 days, told she can't walk at graduation.
A full ride means so much, and that is on the line right now.
Her future possibly stripped, all because of a shirt. Summer says it's a lot to shoulder.
It's just sad because I worked so hard for 4 years to walk across that stage, and we have drug dealers walking across that stage, and we have sex offenders walking across that stage, and then the 4.4 student who showed her shoulders can't.
So this is the official suspension letter, and you can see right here the reason for her suspension, technically not the dress code violation, but rather insubordination. It goes on to say that Summer didn't listen. She denied that her shirt was ever a problem. Her mother, though, says she plans on appealing. Reporting live at Hickory Ridge High, I'm Tanya Mendes, NBC Charlotte.
We didn't know whether it was appealed or not, but we don't know. We don't know if it meant. I'll be back in a moment. Friday night, my explosive rant to the Houston School District, and for not helping out an autistic child when an adult kicked that autistic student, autistic third grader. Remember, the grandmother was very angry. She wanted all the people fired, and now that video showed that the adults did not do anything. They just watched her, like watching a boxing fight at the WWE. That's tomorrow. And then as American Ass, an updated version. We did one on my old channel, but I'll explain why on Friday. So look for that. So look for that on Friday. That's all for this edition of Give Me a Break Wednesday going to Thursday. We'll see you again for Give Me a Break Friday night from the baseball game or softball game. Well, it all depends on the weather. We'll tell you about it. And for all of us here at Give Me a Break and YouTube, good night.